Now, since Waqf is the integral part of the Islamic legal system, and institution of the Waqf is still in practice in all the Muslim societies all over the world, including in India. Institution of Waqf is recognized as a legal institution or legal subject. As a part of Muslim personal law, it is considered. Since it is a legal term, legal proposition, therefore it was thought necessary to give a legislative or formulate a legislative definition of the term Waqf. Because the definition of the Imam Abu Yusuf was of course a juristic definition, a philosophical definition, a practical definition of the Waqf, but it was not reduced in legal form at that very point of the time. And therefore, on the basis of the juristic work produced by Imam Abu Yusuf, Imam Muhammad, Imam Abu Hanifa, in India, in 2013, the definition of the Waqf for the first time was coined. And time to time, the definition of the Waqf was amended on the basis of the practical difficulties and suggestion given by the philosopher, social philosopher and legal philosopher. Now, finally, the definition of the Waqf was codified by the Indian Parliament in 1995, when a central Waqf was enacted by the central government of India in 1995. And a full-fledged act was enacted in 1995 that is known as the Waqf Act 1995, which was further amended in 2013. And therefore, the Waqf Act 1995 is called as the Waqf Act 1995 as amended in 2013. Section 3 subclass R of the Waqf Act 1995 as amended by 2013 Amendment Act defines the term Waqf, and according to the Section 3 subclass R of the Waqf Act, Waqf means permanent dedication by any person of any movable or immovable property for any purpose recognized by Muslim law as pious, religious and charitable, and includes Waqf by user, but such Waqf shall not cease to be Waqf by reason only of the user having ceased, irrespective of the period of such season. A Samlat Patti, Samla D, Jumla Malkan or by any other name entered in a revenue record. Grants including Masrutul Khidmat for any purpose are recognized by the Muslim law as pious, religious and charitable, and a Waqf al-awlad to the extent to which the property is dedicated for any purpose recognized by Muslim law as pious, religious, charitable, provided when the line of succession fails, the income of the Waqf shall be spent for the education, development, welfare and such other purposes as recognized by Muslim law. And Waqif means any person making such dedication. Ladies and gentlemen, this definition by and large is same as is found in section 2 subclass 1 of the Mussalman Waqf Validating 1913. Section 2E of the Mussalman Validating Act 1923 and section 3 of Waqf Act 1994. So, what is the legislative meaning or legal definition of the term Waqf? Is provided under section 3 subclass R. And in simple word, in view of section 3 subclass R, Waqf means permanent dedication of any property, movable or immovable, by any person for any purpose recognized by Muslim law as religious, pious and charitable. But this definition is not exhaustive but inclusive and also includes some other kind of the dedication as Waqf, which are separately provided under the separate provisions attached with section main limb of section 3 subclass R. Ladies and gentlemen, when section 2 subclass 1 of the Mussalman Waqf Validating Act 1913 was enacted, thereunder under section 2 subclass E of the said act, definition was formulated, and then time to time it was amended, and in 1995 it was finally codified. Again it was amended in 2013, and the basic change which was made through the various amendments was that under the Mussalman Waqf Validating Act 1913 and up to 1995, Waqif was could be only the Muslim person professing the Islam, meaning thereby non-Muslim could not be the Waqif according to the earlier definition, which was contrary to the rules of Waqf under Muslim law. Because according to the Muslim law, Waqif can be any person, Muslim or non-Muslim, Jew or any other person belonging to any other sect. And this is evident from the fact that during the lifetime of the Holy Prophet himself, there was a Jew, Mukira. Mukira by religion was Jew, he did not accept the Islam, but he was supporter of the cause of the Muslim. He was owner of various immovable properties, valuable. Therefore, in his last stage, he dedicated certain valuable properties as a waqf, which was accepted by the Holy Prophet as a waqf, and such properties continued to be waqf even after the death of the Jew Mukira. On the basis of this, and there are so many other evidences showing that non-Muslim can be waqif. But when the definition of the waqf was formulated by the parliamentarians, this part was diluted and it was made that waqif can be only a Muslim. A non-Muslim cannot be waqif under the Muslim law. Therefore, a lot of objection in the form of the suggestion was sent to the government, and finally the government in 2013 agreed upon and amended the main limb of the definition of the waqf as given in section 3 subclass R, and it was held and it was codified that now the waqif can be, and therefore in 2013 section 3 subclass R was amended and it was laid down under section 3 subclass R. Waqf means permanent dedication by any person. However, what is the basically waqf? What is the concept of the waqf? Who can be the waqif? That is another thing. But what is the waqf basically? That was clarified by the Privy Council in Vidya Varuthi versus Balu Swami Iyer case. Because for the first time the definition of the Waqf was formulated in 1913 when Mussalman Waqf Validating Act was passed, and therefore on the basis of the law of the Waqf, definition of the Waqf given under the Waqf Act 1913, Privy Council in 1921 clarified what is meant by the term Waqf in Vidya Varuthi versus Balu Swami case. And the court said, the Mohammedan law relating to the trust differs fundamentally from the English law. It owes its origin to the rule laid down by the Prophet, peace be upon him, of Islam, and means, this is the meaning of that Waqf which is given by Privy Council in Vidya Varuthi versus Balu Swami. So, what is the meaning of the term Waqf? Privy Council says, Waqf means the tying up of the property in the ownership of the God, the Almighty Allah, and devotion of the Prophet or the being for the human beings. When once it is declared that a particular property is Waqf or any such expression is used as implies the Waqf or tenor of the document source, it will be called as Waqf. In the case of Jivan Das Shahi versus Shah Kabiruddin, the court further held that a dedication to pious or charitable purpose is meant, the right of the Waqif is extinguished and the ownership is transferred to Almighty. The donor may name any meritorious object as recipient of the benefit. The manager of the Waqf is called Mutawalli, governor, superintendent or curator. Subscribing to the opinion of the Privy Council in Vidya Varuthi versus Balu Swami Iyer, read with Jivan Das Shahi and Shah Kabiruddin, Supreme Court of India in Sayyid Ali versus Andhra Pradesh Waqf Board, year 1990, held that a Waqf means a permanent dedication of the property for the purpose recognized by Muslim law as pious, religious or charitable, and the property having been found as Waqf would always retain its character as Waqf. In other words, once a Waqf, always a Waqf continues to be so for all the time to come, and further continues to be governed by the Waqf Act and the grant of patta in favor of, and does not affect the original character of the Waqf property. Thus, the definition of the Waqf as given in section 3 subclause R of the Waqf Act 1995 was restrictive, as it included only the dedication by a person professing the religion of Islam, and therefore according to that act only a Muslim was entitled to create a Waqf, and a non-Muslim was prohibited to create the Waqf or to be the Waqif. Whereas the Hanafi law clearly allows a non-Muslim, not Muslim law clearly allows a non-Muslim, a non-believer to create a Waqf, so also other school of Islamic law. It is stated in the Islamic jurisprudence that it is not essential that Waqif should be necessarily a Muslim. A non-Muslim could dedicate his property as Waqf. There are examples. The history of the Islam records the example where the Waqif was a non-Muslim and Waqf was created by a non-Muslim. Amir Ali says that in Islam it is not necessary condition for the constitution of the Waqf that Waqif should be a Muslim. Any person of whatever creed may create a Waqf, but the Muslim law requires that the object for which the dedication is made by a non-Muslim should be lawful according to the creed of the dedicator as well as the Islamic doctrines. Therefore, section 3 subclass R was amended in 2013, whereby a non-Muslim was allowed to create a waqf provided the object of the waqf is valid according to the Muslim law. As per section 3 subclass R, a waqf alal awlad is also a waqf within the meaning of this Waqf Act 1995 as amended in 2013, but only to the extent to which the property is dedicated for any purpose recognized by Muslim law as pious, religious or charitable. The court in Tamil Nadu Waqf Board versus M. Ibrahim, year 1975, held that Waqf alal awlad are of two kinds: Waqf alal awlad simple sitter and Waqf alal awlad composite. Thus, section 3 subclass R was amended into 1995 and was not in conformity with the Muslim law dealing with the Waqf alal awlad. Hence, it was amended to bring the Waqf alal awlad as a whole within the ambit of the scope of Waqf Act 1995. It may be informed that government has proposed. Now, here it may be clarified that now, according to section 3 subclass R of the Waqf Act 1995 as amended in 2013, there is a broader and inclusive definition of the term waqf. And waqf can be of any property, movable or immovable property, and waqf can be created by any person who is the bona fide owner of the property. Waqif can be a Muslim or even can be a non-Muslim. What is the condition for creating a valid waqf is that there must be permanent dedication of the property, and the object of the dedication should be either religious or pious or charitable according to the Muslim law, recognized by Muslim law, not according to the belief of the dedicator. Therefore, where the waqif is non-Muslim or where the property has been dedicated as waqf by a non-Muslim, the object of the waqf should be according to the Muslim law. Purpose for creating the waqf should be recognized by Muslim law as pious, religious or charitable. For example, where there is a non-Muslim and he dedicates his certain properties as a waqf, providing that income arising from the waqf property will be applied to feed the poor of a particular locality or to help the poor of a particular locality. Now, the helping the poor is recognized under Muslim law. It is a recognized object of the, it is a good object recognized under Muslim law. Therefore, here the waqif may be a non-Muslim, but since the waqf object of the waqf is valid according to the religion of the Islam, therefore waqf will be perfectly valid and it will be as good waqf as the waqf created by any non-Muslim. Ladies and gentlemen, now again some amendment is proposed vide a bill known as Waqf Amendment Bill 2024. And by this amendment, about 40 to 43 amendments are proposed to be effected by enacting a fresh law on the subject of the waqf. And some major changes are proposed in the definition clause of the Waqf Act 1995 as amended in 2013. In the definition clause, in place of any person professing the Islam for 5 years is proposed, which is going to alter the basic concept of the waqf. Because under the Waqf Act 1995 as amended in 2013, any person is allowed to create the waqf by dedicating his property for any good human cause recognized under Muslim law as religious, pious or charitable. Now the amended provision will be that waqf means permanent dedication by any person professing the religion of the Islam for 5 years, meaning thereby that any new Muslim cannot make the waqf of his property unless he has completed as a Muslim 5 years. This is the and there is an objection of the stakeholders on this change, where the government is trying to make it the integral part of the Muslim law. Since Muslim law is applicable only to the Muslim, therefore non-Muslim has been kept out of the ambit of the waqf. That when it is a part of the Muslim law, then only the Muslims should be allowed to create the waqf, and a non-Muslim should not be made entitled to create the waqf. And even if a non-Muslim who has accepted the religion of the Islam, he should not be allowed to create the waqf or to dedicate his property as a waqf unless he has completed the 5 years as a newly embraced and as a new Muslim. So this is one of the changes which are proposed to be made in the definition clause. Further, the proposed amendment seeks to delete the waqf by user from the main limb of the definition clause, because until 2024, under the Waqf Act 1995 as amended in 2013, waqf means permanent dedication by any person of any property by any person for any purpose recognized by Muslim law as religious, pious and charitable, and also includes waqf al-awlad, waqf by user, grant, deed, samlat, all these are included within the meaning of the term waqf. Now the proposed amendment 2024 Waqf Bill seeks to delete some of the clauses of the section 3 subclause R. One of the clause which is proposed to be deleted, that is relating to the waqf by user. Here waqf by user means waqf which means the property which has been used as waqf for a longer period of the time. Such waqf type of the dedication are known as waqf by user. Now the government has made a proposal that waqf by user should be deleted. Means any property which is known as a waqf simply on the basis of its use as a waqf will no more be as a waqf within the meaning of section 3 subclause R. Waqf al-awlad is also proposed to be diluted to some extent, and in the proposed amendment it will be ensured that by waqf al-awlad in any way the share of the female should not be adversely affected. This type of the proposal is made to bring the change in the. Anyhow, if the change is made, then the definition of the waqf as given in section 3 subclause R of the Waqf Act 1995 as amended in 2013 will be a totally changed concept. And the changed concept may be different from the jurisprudential concept of the waqf, and therefore Muslims are stakeholders, they are opposing the amendment. The opposing means that they are not agreeing with the proposed amendment, and suggestions have been, therefore suggestions were invited from the stakeholders. Different organizations, they have moved their proposal to they have moved their suggestion to the select committee, members of the select committee, and they are within the cognizance of the select committee, and hope the due consideration will be given to the suggestions made by the stakeholders before taking the final call on the amendment of the Waqf Act 1995 as amended in 2013. But anyhow, Section 3 subclause R is going to be substantially amended, and thereby the concept of the Waqf will be entirely different from the concept of the Waqf as is given in present Act under Section 3 subclause R. Ladies and gentlemen, now I proceed to discuss essentials of a valid Waqf. Following are the essentials of a Waqf as defined in the main limb of Section 3 subclause R of this Act, that is Waqf Act 1995 as amended in 2013. And they are: number one, there must be dedication of the property by owner. Second, there must be dedication of the property. The dedication of the property must be permanent. Third, the subject matter of the dedication must belong to the dedicator or waqif. Fourth, the dedicator may be any person belonging to any religion. And the object of the dedication must be religious, pious or charitable as recognized by Muslim law. Now, what is the meaning that the first ingredient of a valid Waqf is that there must be dedication of the property, permanent dedication of the property. Waqf is created by dedication of any property for any object of religion, piety or charity recognized by Muslim law. A valid dedication extinguishes the ownership of the settlor once and for all, and the property becomes inalienable. If the settlor retains any control or dominion over the property, such a dedication is not valid. According to Imam Abu Hanifa, the property on dedication vests in mutawalli or manager, who may be the settlor or waqif himself or anybody nominated by him, but his illustrious disciples Imam Abu Yusuf and Imam Muhammad opined that dedicated property vested in Almighty God and its profit is applied for the benefit of mankind. Under Shia school, the property vested in the beneficiaries. It was observed in the case Jawahar versus Akbar Hussain. When anyone has resolved to devote his property to religious purposes, an endowment is immediately constituted. His act deprives him of all the ownership in the property and it wastes in the God. In such a manner, I subject it to the rules of divine property when the appropriator's right in it is extinguished and becomes a property of God by. So, the dedication need not be in writing, it may be oral, but declaration of dedication must be clear and unequivocal. Dedication may also be by deed or by interviewers. So, there must be a dedication of the property means the dedication here means that Waqif should divest of his ownership right, should divest himself of ownership and control over the property. As soon as the declaration is made that certain property is dedicated as Waqf, and by some act or conduct it is shown that dedicator or waqif divested himself of all the ownership right and control over the property, such property will be regarded as property dedicated for waqf. However, the dedication must be permanent. Permanent a waqf for a limited period of time is wide. The position is same in both the school of Muslim law. As pointed out by Amir Ali, a waqf in order to effect in perpetuity must be for an object which is individually or collectively would presumably be last forever. Perpetuity can therefore be presumed from the nature of the objects for which the dedication is made. A charitable purpose is per se perpetual in nature, for the poor are always in existence. Therefore, the rule is that dedication must be permanent. Subject of the dedication must belong to the dedicator, means when somebody is making the property, dedicating some property as a work, it is necessary that while he is making the property as a work for dedicating the property as a, he should be the bona fide owner thereof. If he was not a bona fide owner thereof, the work will not be a valid work according to the Muslim law. This has been clarified by the court in Musammat Piran versus Hafiz Muhammad Ayar 1966. The dedicator may be any person belonging to any religion. This was the position, and this is the position till now, because under the section 3 subclause R, it is clearly given that the Waqif can be any person, may be Muslim or may be a non-Muslim. What is necessary, that object of the work should be valid according to the basic principle or fundamental rules of Muslim law. Therefore, if a Christian were to make the dedication for a building where the Almighty God may be worshipped according to the rites of Islam, such a declaration would be valid. The object of the dedication must be religious, pious, or charitable. This is the essence of the waqf, because waqif may be anyone, but the object of the waqf must be valid according to the Muslim law, and the object will be valid according to the Muslim law only when it is religious, or it is pious, or it is charitable. If the property is dedicated only for any secular purpose, it will not be valid. It will not be a valid waqf under Muslim law. For example, if somebody dedicates his property for running a cricket club, so there is no element of religiosity or charity is involved therein. Therefore, it will not be a valid waqf according to the section 3 subclause R of the Waqf Act 1995. Now, in this way, I have tried to explain what is the waqf and what are the essentials of a valid waqf according to section 3 subclause R of the Waqf Act 1995 as amended in 2013. Thank you very much.